It's challenging to unpack the DOJ letter because it contains so many factual, legal, and typographical errors. The main winners, from Judge Brown's opinion, are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. What the fuck? The lawyers are involved as well. Excuse me, sir. Are you a journalist or a lawyer? Where are the legal arguments? Hello? On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. Wait, do you understand what happened here? Judge Brown here is being misquoted by this guy, the Jerry dude. In August 2025, the state of Texas enacted a new electoral map to govern elections for the U.S. House. Okay, this is a big deal because this is a circuit court ruling. So remember, in the federal court system, so if you're bringing a case in the U.S. to a U.S. court, not a state court, a U.S. court, the federal courts are located in states because you have to be somewhere geographically. But your first court is your district court. So the Southern District of Florida, Southern District of New York, whatever. And then when you appeal, you go up to your appeals court, which are your circuit courts. And then if something goes, the next step from a circuit court would be the U.S. Supreme Court. So my understanding is that this is oh wait, I thought Kafka said this was a circuit court decision. This is a district court decision right now. So this will be appealed up to the circuit court, Supreme Court, if it got that high. The scary thing about this for the Trumples, though, is that if they can't get, I don't know what these guys are arguing for. Let me read a little bit. There's a world where if the judges don't rule favorably on this, basically they don't get their redistricting done in time for midterms. That would just be an unbelievable, horrible outcome that Texas basically got the okay from Congress and Trump, go ahead and redistrict. And then Newsom said, oh, well, we're going to redistrict California then. Democratically, we're going to do it. California gets their Prop 50 redistricting done, and then Texas gets theirs rolled back. That would be crazy. That would be such a horrible outcome for Republicans. Okay, August 2025, the state of Texas enacted a new electoral map to govern elections for the U.S. House of Representatives, claiming that the 2025 map is racially discriminatory. 6 groups of plaintiffs, the plaintiff groups, ask the court to preliminarily enjoin the state from using the 2025 map for the 2026 elections. For the reasons explained below, the court preliminarily enjoins the state from using the 2025 map. The court orders that the 2026 congressional election in Texas shall proceed under the map that the Texas legislature enacted in 2021, the 2021 map. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. Chief Justice John Roberts. Public perception of this case is that it's about politics. To be sure, politics played a role in drawing the 2025 map, but it was much more than just politics. Substantial evidence shows that Texas racially gerrymandered the 2025 map. Here's why. Is this a judge reading this? This language feels a lot more informal than what I'm used to reading in these. California Prop 50 was based on the Texas thing. It doesn't matter if the Texas stuff gets blocked. I think they can still go through with this. Earlier this year, President Trump began urging Texas to redraw its U.S. House map to create 5 additional Republican seats. Lawmakers reportedly met that request to redistrict on purely partisan grounds with apprehension. When the governor announced his intent to call a special legislative session, he didn't even place redistricting on the legislative agenda. But when the Trump admin reframed its request as a demand to redistrict congressional seats based on their racial makeup, Texas lawmakers immediately jumped on board. On July 7th, Harmeet Dillon, the head of the Civil Rights Division at the DOJ, sent a letter to the governor and attorney general of Texas. We saw this is what was on Twitter, making the legally incorrect assertion that 4 congressional districts in Texas were unconstitutional because they were coalition districts, majority non-white districts in which no single racial group constituted a 50% majority. In the letter, the DOJ threatened legal action if Texas didn't immediately dismantle and redraw these districts. That's bullshit. They were never going to do anything. This is pretextual, meaning they just said this to say, oh, look, now Texas has to do it. Oh. A threat based entirely on their racial makeup. Notably, the DOJ letter targeted only majority non-white districts. Any mention of majority white Democrat districts, which DOJ presumably also targeted if its aims were partisan rather than racial, was conspicuously absent. 2 days later, citing the DOJ letter, the governor added redistricting to the special sessions legislative agenda. Plaintiff can bring a racial gerrymandering claim under the 14th and 15th Amendments. A racial gerrymandering claim alleges that the state, without sufficient justification, has separated its citizens into different voting districts on the basis of race. Plaintiff must prove the state subordinated race-neutral districting criteria. It is not illegal for a legislature to enact a redistricting plan with the purpose of favoring one political party over another. When a plaintiff brings race-based gerrymandering claims, partisan motivations acts as a defense, not a jurisdictional bar. These principles likewise prove critically important below. In Rucho versus Common Cause, the Supreme Court ruled that partisan gerrymandering claims aren't cognizable in federal court. What do we mean when we say that? They don't have the legal authority. It's just not a thing that you can really... Partisan gerrymandering claims present political questions beyond the reach of the federal court. So it's like, okay. It's just not, so that's not a question for a court to decide. Okay. Subject to legal restrictions that exist in some states, but not in Texas, It is not illegal for a legislature to enact a redistricting plan with the purpose of favoring one political party over another. When a plaintiff brings race-based gerrymandering claims, partisan motivations act as a defense, not a jurisdictional bar. These principles will likewise prove critically important below. Ooh, okay. So that's a little counterintuitive. Somebody says, you actually, you were race-based districting or whatever. Or hold on, the plaintiffs in this case are people challenging Texas. So those people are saying you're race-based districting. And then on the other side, they have to prove that they weren't race-based districting, but they could use partisan districting as a defense of that. They could say, no, we just wanted to favor Republicans. That argument wouldn't be illegal. That would actually be a valid defense. We were doing a partisan redistricting, not racial redistricting. One of the best uses for AI is finding out where words come from. It helps you understand things better. I think it would, maybe if you have like the Lexis or Westlaw AI, you have to be careful for legal terms because legal terms can have very distinct legal meanings that sometimes AIs won't always get. Like there are words that we use that are common words like obscene, but it has a particular legal definition. It's an important legal definition. That doesn't just mean like wacky and crazy. 4 years before the legislature enacted the 2025 map, challenged here, the state redrew its congressional map to account for population shifts in the 2020 census. 4 of the 2021 map's congressional districts are especially relevant here. The first is CD9 in the Houston area. Although CD9 was majority non-white under the 2021 map, no single racial group constituted a 50+% majority by CVAP. The district was 45% black, 25.6% Hispanic, 18.1% white, and 9.3% Asian. What is this? Bro, districting in the US is fucking wild. Damn, these guys are almost completely surrounded. It's like they're playing the blob game. Sponsor of that bill that became the 2021 map, Senator John Huffman, stated repeatedly that the map makers did not look at any racial data as they drew the 2021 map. Instead, they based the district boundaries exclusively on race-neutral considerations like partisanship. The plan that the map makers drew on partisan grounds appeared to also satisfy VRA Section 2 Voting Rights Act, as Campos interpreted it, so the legislature passed the map. If we take Senator Huffman at her word, then any coalition districts that ended up in the 2021 map were a coincidental byproduct of the legislature's decision to draw district lines based on race-neutral considerations like partisanship. In other words, there's no evidence in the preliminary injunction record that the legislature purposely drew coalition districts that it wouldn't have otherwise drawn based on concerns that a court would otherwise invalidate the 2021 map under Voting Rights Act Section 2 and Campos. Thus, there's no indication that the 2021 legislature placed a thumb on the scale in favor of minority coalitions based on a now discredited interpretation of Section 2. It's challenging to unpack the DOJ letter because it contains so many factual, legal, and typographical errors. Indeed, even attorneys employed by the Texas Attorney General, who professes to be a political ally of the Trump administration, described the DOJ letter as legally unsound, baseless, erroneous, ham-fisted, and a mess. Oh no. Destiny, how is this kind of loophole even allowed? Like if a party was just overtly racist and they gerrymandered only for them? Well, when it comes to arguing racial stuff, you can also argue effect. You don't have to argue just cause. You can argue effect as well. So like if I were to say something like, I'm going to make it so police arrest everybody that buys Jerry Curl or whatever, like that, like if the effect ends up, being like 99% some racial group or whatever, then like that can get struck down as well. For the foregoing reasons, the court grants the plaintiff group's motions for a preliminary injunction. As to their racial gerrymandering claims, plaintiff Texas NAACP's motion for a preliminary injunction, plaintiff intervener's motion for preliminary injunction, the Gonzalez plaintiff's motion for preliminary injunction, the Brooks, Alulac, and Malk plaintiff's joint motion for preliminary injunction. The court thereby enjoins the state of Texas 21 maps and orders the state to use 21 maps. So they should appeal this. I imagine they'll appeal this district court decision. There's a cope argument that this invalidates Prop 50 because it originally was supposed to only trigger if Texas went through the new maps. Nope, we read that. I don't know, or that might be a cope argument, but we read the Prop 50 addition to Article 21 or whatever, and it doesn't do that.
Okay, yeah.
Like this looks, assuming the legal arguments are true, and they're not, and this court is not getting anything wrong in the first couple paragraphs. They said that there's nothing so far in the record. So for a preliminary injunction, both sides have the right to present evidence to the judge, and it sounds like the defendants in this case, which would be the Texas Attorney General, the Texas Department of Justice, or whatever, have submitted absolutely nothing in the record to demonstrate that the districts were drawn along racial lines. And if they haven't submitted any evidence of that, I feel like they probably need that if they're going to win their case, and all this evidence should be public because this redistricting stuff is not done like, in secret. So that seems pretty bad for them, but yeah, what's your take?
So, okay, I think you might have misspoke there real quick. What? There's no evidence that the redistricting was done on partisan lines. There is an immense amount of evidence, explicit evidence, that it was done only based on racial lines.
Wait, really?
Wait,
I read that completely backwards then. Hold on.
Yeah. there is an overwhelming amount of evidence that this was done racially and without an intent to do it partisan.
Wait. I'm sorry. I'm referring to the redistricting that was done in 2021. Are you referring to the current redistricting?
I'm talking about the current one. Yes, in
Oh, yeah,
2021, there's no evidence. There's
Yeah.
no evidence that there was any racial.
So
I'm
right now
sorry,
they're
yeah.
trying to say that the 2025 one, I guess, now that they're trying to get rid of Section 2 or whatever, the Voting Rights Act, they're saying they can do it on racial lines. But the argument I think that the plaintiffs are using is that, well, in 2021, that was done on partisan lines, not on
Right.
racial lines, which means it was legitimate and you can't just undo it or whatever. There would be a different process or something. Or you can't undo it just based on the bullying from the government or something. Yeah.
So then the yes, and the way that they're getting there is they're saying, hey, there used to be this thing called a coalition district, and it goes over this on page 6, where like for like what is it, like 36 years, the Fifth Circuit said, hey, if you could get a group of minorities together of 2 or more races, okay, that would allow you to meet a different precondition from this other case that would show that the vote dilution has been happening.
Sure.
And so it's this kind of complicated thing where they're saying, okay, we had this old map was drawn in a way that had these coalition districts. So we're coming in to break up these coalition districts because actually that case it did get overturned in 2024. However, it doesn't mean that they can then come in and change those districts based on race.
Sure. Yeah. Okay.
And so then what's happened is like every piece of Republican like correspondence and public statement on this has explicitly said this is about race. There's even a statement from the governor where he said this is not about race, and if there's any benefit to the Republicans, it's incidental. Like there's a very, very detailed analysis of the computer programs used to draw the maps that's included in here. The way that the legislative session was called shows that it was entirely relying on the federal letter that asks them to redraw it based off of race. So like there's the letter that said, hey, we want you to redraw it based on race. And then they called the legislative session that in the agenda, it did not say they were going to do redistricting.
Yeah.
And then the governor came out and said, I want you guys to add it because of the letter that the federal government sent me. So there's literally no way to get away from the fact that this isn't we don't even need to get to the vote dilution or the effect. Anything. It's just the intent is so plainly obvious. They don't need to go on, but like they still examine it. And then on top of that, there's a lot of places where there was like white majorities that weren't touched. There's a Republican district where it was 65% Hispanic and conservatives won that district, and then they still redistricted it to reduce the amount of the Hispanic percentage in it. So it's like they literally all they did was change that district so it was less Hispanic.
Sure.
And it's like, yeah, it's just so overwhelming. And there's some
For
there's
fellow
some stuff
retards, quick question. You're saying that they changed the reason the new map happened is because they were claiming the old map was racially tied, correct?
Yeah, they're saying there's
Okay,
they're saying there's a racial intent and effect behind the old maps with zero evidence, as Destiny said before. There's no evidence of it, and there's ways to show that. There's even ways to show like an implication.
Yeah. Okay. So basically, what happened was there's a thing called the Voting Rights Act. Okay.
Mm-hmm.
And in Section 2 of the Voting Rights Act, you can't discriminate, I think, on voting-related stuff, voting practice or procedures. You can't discriminate based on race, okay?
Or gender, I would assume, but yeah.
No,
it's race.
Gender's
not it was part of, I think race. Was this part of the Civil Rights Act or a bill accompanying the Civil Rights Act? But it was 1965, so it's...
Yeah, around there, yeah.
So what they're saying is, what happened was the U.S. Congress, the United States Department of Justice, I don't know what the Supreme Court case was, but so I think there was was there a Supreme Court case that changed their mind on how you could district things? That like basically people were saying you can do racial districting and that doesn't violate Section 2 of the Voting Rights Act. But I think the Supreme Court just recently changed their mind and said, actually, if you racially redistrict, that does violate Section 2. Is that what this is?
By recent, do you mean like within like the...
It's the Fifth Circuit, not the Supreme Court. Sorry.
Okay, it was a Fifth Circuit decision?
Yeah.
Okay.
There was a question of a racial nature that was decided, and it does not do what the government says it does. It has something. It's totally unrelated to what they're claiming it does.
Okay, sure, but okay, so basically,
yeah.
what they're saying is, okay, so the Fifth Circuit, Texas is part of the Fifth Circuit, right? We've got these massive circuits that encompass multiple states. These are the your first level of appeals courts for federal courts. Okay, so Mr. Moon, okay, so the government, the United States government, okay, Pam Bondi, the Department of Justice, they basically go to Texas and they say, hey, you guys had a Fifth Circuit decision, okay? That's the courts that you're part of. And they said, you guys can't consider race to do your districts. So the maps that you guys drew in 2021, those are unconstitutional and they're bad and you need to redraw them or we're going to sue you guys and make you redraw them. Now, it's probably a strained legal interpretation. It's probably bullshit. The Fifth Circuit interpretation is not, this is probably not true. And also, it's not a genuine threat from the U.S. government to the state of Texas, but it gives Texas a reason, Abbott, the governor, and Paxton, their attorney general, to go, oh, well, I guess we got to redraw, guys. Let's go get rid of these 5 Democratic districts, okay? But that argument from the letter that the DOJ sent to Texas is saying, because of what your Fifth Circuit said, you guys can't draw districts based on race. So now you guys need to redraw those 5 districts. Well, now what has happened is that a Texas court, a U.S. court in Texas, okay, their district court, has said, well, actually, if you go back and you look at the 2021 districts that were drawn, these districts that were drawn weren't drawn for racial reasons. These were done on a partisan basis. It wasn't drawn. They weren't drawn for racial reasons. So whatever, even if we go with this dumb interpretation of your Fifth Circuit decision, you can't undo
we shouldn't have to redraw
districts because they weren't done on a racial basis. And it doesn't seem like right now the government, the defense in this, the state of Texas, has produced any evidence that those maps were drawn for racial reasons in 2021. But it does seem like they want to redraw them for racial reasons in 2025.
Got it. So, and that was Trump's Department of Justice who did that?
Trump's DOJ is the one that, was bullying Texas. It's a pretextual thing to get them to redraw the districts to get more Republican districts,
Okay. Could that be, like, illegal?
What do you mean?
If they have no proof?
The letter that they sent?
Yeah, like the letter that they sent. Like, let's say they have zero proof that it was done on racial or whatever, but
apparently
they're saying
there's all these like rules of civil procedure. Supposedly there's like sanctions in districts, but now from my own personal experience and now from watching how the government acts, I actually think you can just file whatever fucking case you want in any fucking court. It doesn't matter how fucking retarded your argument is. People will listen to you say dumb shit. Like, in my opinion, court in the United States is basically expensive therapy. If you want to go and you want to vent some argument, the judge will be your therapist and he'll listen to you, and you have to fuck up really fucking hard in order to get in trouble for it. So
it's not a horrible explanation. I mean, like there's no recourse against the government for these things that are happening right now. There's no like damages that you could get out of this. It would just revert back to the older maps. That's the result that we're looking for.
Well, I mean, I feel you could argue some forms of damages or some forms of what do you call it, like vexatious litigation. You can sanction people for bringing bullshit theoretically, right? There's like
no. But they're suing the government right now. The government's the defendant. So how would you sue the government for vexatious litigation right now? That's what I'm saying. This current case that we're looking at right now, if we want Texas to revert back to the older maps, I'm not sure what you could sue the government for.
Well, because technically they quote unquote threatened legal action. They didn't actually take any. So yeah, that's true.
Right. Yeah. But like, if you were to be, say, sued for a totally bullshit reason that was shown in court to not be true at all, there's potential to go for the vexatious litigation. It's really fucking hard to get, and judges do not like those cases at all. So it has to be pretty egregious.
Yeah, very egregious. When you say pretty egregious, the standards for this stream are very high, but egregious means like insane. Not like this guy's using an argument that's obviously retarded, but like, this guy is using the unbelievably fucking most retarded argument in the fucking universe. Yeah, this is like
paper terrorism plus like a huge amount of prejudice that would result in like personal damages outside of the courtroom. Those are the kind of things that you would want to like show. And then also, if it was just the first time, a lot of the times they're like, maybe if he does it a few more times. Like, I know in some states it has to be like 4 times before they'll ever actually do anything about it.
Sure.
So like in a normal reality, let's say we have a functioning president who sees that his head of the Department of Justice sent this letter with like quote unquote zero founding, etc. Wouldn't we want the normal president to like remove them for being literally retarded?
Well, it's hard because the tradition and norms is that the president of the United States has, in order to carry out faithfully his duties as executive, He has departments that exist in the executive branch, and he has officers at the heads of those departments that he's allowed to nominate, and then he appoints them with confirmation from the U.S. Senate, and they're the ones that head those departments to help him carry out his roles. They're not supposed to be puppets for him. Now, if you've ever heard the phrase unitary executive theory, some conservatives are running with this idea that actually the reality is we really wish that like God could be president and could literally do every single job on his own, but because we have limitations as humans, we have other people that are appointed to these roles, but they really are just an extension of the president's own mind and will. So in the real world, what would happen is if you thought as president that this was a thing that you could do, then you would what you would do is as president, you would go to your Department of Justice and you would go, hey, what do you guys think about this legal argument? And you would say, Eric Holder was the was he the head of the Office of Legal Counsel? Who was he in Biden's, or not Biden, I'm sorry, in Obama's White House? Fuck.
That's a good question.
What was the Holder memo about? Was this about like targeting American citizens? When
AG?
Attorney General, okay. When Obama wanted to target I forget the name of the guy, but he was working with Al Qaeda, I think, and he was an American citizen, and Obama wanted to target him overseas. Instead of just doing it and saying I can do whatever the fuck I want, Obama went to his Department of Justice and he asked them, do I have the legal authority to do this? What do you think? Investigate. And then they go, and these are some of the brightest people in the United States, well, before this administration, who will dig up the legal answers, they'll do the research, and then they'll give you a memo, and they'll say, here you go. What Trump does is Trump goes to the Department of Justice, and he gives them orders. He doesn't care what the legal argument is. He just orders them to do a thing. So the norms...
And they say, yes, sir, I'll do it.
I'll figure out a way to do whatever you want, yes. Whether that's arguing process and procedure, whether that's arguing substance, whether that's making some bullshit up, whether that's whatever, they'll just do whatever he asks. So that's why right now the DOJ is in such a sorry fucking state. It's because it's just working as an arm of Trump's personal will. It's not actually functioning as a semi-independent body in the executive that's supposed to be doing good legal work.
Which is why we have him on Twitter, or on, I guess, True Social, saying so-and-so should be tried, and then they are now under investigation, etc.
In my opinion, unless I'm missing some part in U.S. history, this is one of the most egregious oversteps of presidential executive authority insofar as operating the DOJ for lawfare. The idea that these are the types of things that people fantasized about Obama or Biden doing in the background without even statements that were that strong. But for Trump to literally call three people, like he's calling, like A-ball, corner pocket, I need you, Pam Bondi, to indict these three individuals using this lawyer, and then for that to happen, that's just egregious. I think it's unprecedented. I don't know if anybody's ever done this.
Should that be like impeachable, or are we in a weird argument of I think you said like the
impeachable? Yeah, of course. Trump has done 4 million impeachable things, but impeachability is that's a political question.
Judicial question.
Yeah, that's a political question to be dealt with by Congress.
Which won't happen because
the Republicans
houses.
Yeah,
spineless.
Yeah.
Well, yeah, and so you were right in that like the direction of the DOJ is certainly unprecedented and is obviously horrendous and stuff, but also it's not only does this letter that we see in this case, but the many cases that have been coming out recently and the trials that have been going on has been showing the absolute kind of just dearth of horrible lawyers that are in the DOJ. So what they're trying to do is they're trying to use the DOJ to enact his will, but it doesn't seem like they have competency such that they can actually win these cases, even if they had the legal backing. So what you'll see is if you go and read some of the charging documents and things like that are coming out of the DOJ right now, they are written like press releases. They're overwritten. They have a bunch of like very, exciting facts and gigantic allegations that have no business being there, but they know Fox News will publish them, and they know ONN will publish them, or whatever it's called, and OAN will publish them. And so they're just using the DOJ as a form of like intimidation and propaganda, essentially, because they're shooting for settlements, they're shooting for people to fuck off, and they're just using to say, look, we filed this lawsuit. And for most people, when they see a lawsuit get reported on of the DOJ is suing this person, they don't understand the process and they think that person's already convicted and guilty. Way to go, Trump, you convicted these people that you accused of mortgage fraud, right? So that's kind of like the point of a lot of what's going on.
Yeah. And the issue too that you're running into is that generally people that like, if you're like, if you're working as a U.S. prosecutor, these are some of your most, I think, prestigious jobs, arguably, maybe aside from like clerking, like in law, right? Like you're like a U.S. federal prosecutor, especially some districts. These deal with huge federal cases. Like these people want to clerk for them. They want to work in these offices. These are just very prestigious jobs. But there's been a big loss of talent in these prosecutor offices because people don't want to work for this administration because the arguments are ridiculous. They're lunatic. Like Kafka said, yeah, like you can make strained legal arguments, but these are beyond that. They're just the worst. I didn't read this fully. I read some of this, but supposedly one of the I don't know if the judge just was ruling on this related to the grand jury indictment of Comey.
Yeah.
But is it Lindsay Halligan, who I think is she's right now, she is a prosecutor who's working out of the Eastern District of Virginia.
I thought she was the U.S. attorney out of the Eastern District. Which is a prosecutor. I'm just saying that's a more offensive thing that she's a U.S. attorney.
U.S. attorney. Yeah, in the Eastern District of Virginia. So I think her background is in what is like insurance law
Insurance defense. Yeah. Insurance defense.
It's typically like I believe people will take pretty predictable paths to different sections of law. So like if somebody is like a judge, I think they're normally you're an attorney first, right? And then like you'll clerk for judges. Yeah. Like it would be very weird if a guy went to law school and then worked in Big Law, New York to do like corporate litigation, and then went down to California to do like environmental protection, like defense, and then was suddenly like nominated to be a federal judge with no other, like that would just be a very strange, like, yeah. So this lady has no background in, I don't know if she has any background in criminal anything.
No, she's zero.
Yeah.
This
so
is the first time she ever presented to a grand jury.
Yeah. If you ever watched any of the Jan 6 stuff when I was going over it, one of the big deals was that people were roasting because there was this huge meeting, I think, on January 3rd where Trump was trying to get rid of the attorney general, which is your biggest prosecutor in the whole country. That's the head of the Department of Justice, and replace him with a guy called Jeffrey Clark, who had never done anything criminal. And I think, was it Hirschman or whatever, were making fun of like this guy wouldn't even know where to go to get a grand jury indictment. This guy couldn't even find the grand jury. He's never done criminal anything in his life. Why would you make this guy the head of the grand
I mean, he's got Kash Patel leading the fucking FBI.
Kash Patel is more qualified, I believe, than this Lindsay Halligan person. Like this, because the arguably head of the FBI, these people are like figureheads. Even you could argue people like your Hegseth, like these are civilian. It's just a different thing, but like. For your prosecutor jobs, I think you should have a background in criminal prosecution. Like, you should be there. Yeah. But like, I think, Kafka, I'm sure you've heard this. My understanding is that she just got roasted, or there's an order out or something that she needs to reply to because the judge was accusing her of telling the grand jury for getting the indictment on Comey, something about using Comey's pleading of the fifth as evidence against his innocence. And the judges, did you hear about this?
Yeah. I was briefly in some conversations about it the other night with Gilmore. He has a very much better understanding than me. But yeah, her handling of the grand jury was so poor, and almost certainly like she broke ethical or at least legal rules around how to conduct that, such that they are now providing the sealed transcript, I believe, of the grand jury to Comey and his counsel, which does not happen. You do not get grand jury hearing transcripts, things like that. They are sealed intentionally against the defendant. It is very hard to get those. For her to fuck up so bad that he is getting that speaks volumes as to how much bullshit these charges are and the actions of this attorney. It's very, very, like, if this happened in any other scenario, this person would resign immediately.
Yeah.
I think this
and
is
keep in mind that like
horrible
grand jury, you just need half the people there. I think it's 23 people and you need 12 or something. Am I right on that?
It's like 24 and you need 13 or something.
But
like that.
Something
one
like
more than a majority. Yeah, one person majority.
And an indictment is done on the standard of probable cause, meaning the cop sees something that looks like weed in your backseat, basically, right? So the standard of evidence is very low for an indictment. Federal prosecutors have like depending on how you measure it, anywhere from like a 90 to 98% conviction rate when it comes to indictments. So if you're indicting somebody in federal court, the grand jury question, I would say, Kafka would agree, or not maybe, is severely overdetermined. You should never having to be fighting with a grand jury to get an indictment. You should be you have way more proof, because in court you're trying to convict at a 99% standard, right? Beyond a reasonable doubt. Getting the indictment should be easy as fuck. So the fact that they're stumbling in the indictment stage, especially on a prosecution where politics shouldn't impact your job, But I mean, to some extent, you have to think about it. You're indicting a former head of an FBI where there's a lot of political questions and accusations around it. These are the most important times where you want to dot all of your I's, cross all of your T's, and make sure everything is by the book. So that's, yeah.
I mean, there's no statute of limitation that they have to fucking run up against, right? Like,
literally, I think the day of,
they should have all of their shit.
Yeah.
They were fucked on the statute of limitations.
Oh,
but also two things on the case with Comey. There was one for the grand jury indictment. There were 3 charges. One of them did not succeed. The other 2 only succeeded by like 14 out of 24 votes. So it was an incredibly thin margin by which they got the indictment on the other 2. And so it like, yes, it's still an indictment, but it's a thing which is like, this is so clearly like on the line. And then if you have any understanding of the facts of the case, it is there's no way this thing it could ever result in a conviction. They just do not have the facts to convict him on what they're alleging. There's a really good Legal Eagle video if you haven't watched it. They go over it plenty, and they're better than I could. But it's just so much bullshit.
But it sucks because once you start these cases, then you get to go fishing, almost similar to civil stuff, but probably even more so on the criminal side of things. Now you can start issuing subpoenas, you can start investigating stuff, forcing depositions, forcing testimony.
You can look into all the shit.
You can go and try to find whatever you want, and now you've got the power of legal authority behind you to compel, meaning with legal authority, force other parties to cooperate. You can go to chat programs, email providers, and demand emails and stuff, and dig and see what you can find, yeah.
Well, and that's why it's so important that Comey is making the legal challenges he is getting that grand jury indictment transcript, because this is throwing that kind of wrench in the works that says, hey, look, like before they dig into my life, look how much they're fucking up. And courts notice this. Courts will take, we'll see this. Courts do try to protect people's individual rights as much as like the meme is that the courts don't care.
Mm-hmm. These are federally appointed judges, correct?
Yeah, these are lifetime judges. They so this guy, I'm not sure who appointed him, but like there are people from the Reagan administration still on the bench. So it's there's all sorts of federal judges out there.
I'm just like, I guess we're kind of in a world where we're getting Trump judges, and what if they start ruling on fucking Trump cases and just giving over like the DOJ,
you got to make
retarded fucking rulings?
There's a big difference between Trump 1 judges and Trump 2 judges also, but go ahead.
Yeah, because the judge in the redistricting case we were just talking about, that was a Trump judge, and they still
Trump 1 or Trump 2?
That was a Trump 1. He was 2019. But yeah, no, I mean, it's good to be skeptical of that. And if you look at a lot of the voting lines, almost all of them are coming down to Trump versus non-Trump judges. Like the tariff case that was recently at the Supreme Court, when it was at its appeals level, it was 2 to overturn the tariffs, 1 to not overturn it. The one that didn't want to overturn it was the Trump judge. So
Supreme Court said they're not going to take that, right?
No, the Supreme Court took an oral argument for the tariffs. They did.
Okay, they didn't take the gay one, I think.
Yeah, they said gay people can stay married for now.
Thank God.
For now.
Yeah, which great, I guess. That's like a good consolation prize. I'm not upset about it, but like, okay, like I don't know. It's a thing where it's like I guess they realize that people are tired of or not interested in hating on gay people as much as people are interested in hating on trans people, because this Supreme Court has issued so many bad decisions around trans rights and things like that. And they do it not only in opinions, but also through the shadow docket, not even giving people the ability to actually like make the argument for why trans rights and trans protections should be upheld, which is
what the fuck is a shadow docket?
So what'll happen is the Supreme Court gets thousands and thousands of cases sent to it every year to appeal, and they don't have time to do them all. But recently, technically, it's existed for a long time, but kind of a more recent thing is they will just issue a ruling on a case that gets appealed to them without any opinion.
Without any like
yeah, no oral argument, and they have the authority to do that, technically. No oral argument. They don't write an opinion. What's been happening sometimes, which has been interesting, is they will do a shadow docket vote, and then only the dissenting liberals will write an opinion. So sometimes you'll see a vote and it'll just say like Justice Ketanji Brown wrote this dissenting opinion, and it's only her words to an order that she disagrees with. And so you're seeing that happen in cases where like they really should be issuing an opinion because it's one that clearly should not have been decided the way it was. It's clearly against precedent, but they're deciding it that way anyways. But by doing this, they're giving Trump what he wants, but not actually overturning precedent. So like, let's say a Democrat president came in, they can say, well, here's the precedent where it says you can't do that. And then if you try to bring up the Trump thing, it's like, well, Yeah, we let Trump do that, but we don't know why. So there's probably a reason why that didn't violate precedent, but you still do violate precedent, right? So it's kind of it's fucked. It's not a good thing.
This is probably one of the best reasons, I think, and it's the most compelling and convincing to me for having a reformation of the Supreme Court, is I think we should just have more Supreme Court justices and figure out how to get more Supreme Court rulings so that they're not so restricted, because it's been, it's a very limited Supreme Court, and you have, so many cases coming through, and they're just so crunched on time.
Yeah, there's no real reason why it has to be like all the judges have to sit all the time for every case. So like the appeals courts of like the Fifth Circuit, they will do 3-judge panels, like in this case, even though this is a district court case. But if you have an important enough case, you can do something called en banc, where you can apply to have every judge in the circuit sit at the same time and deliberate over the case. And however many judges there are, that's how many sit and decide the case. So let's say we have 30 Supreme Court justices, and you only ever get 3 at a time, three Supreme Court justice panel at a time. They make a decision, but then let's say, okay, no, this is important. I want an en banc. Okay, well then we can bring all of them together to do that one en banc. But at least you'd be able to get through way more cases and actually get opinions and things like that.
Yeah.
There's reasons not to do it, but there's also like, there's nothing that's like actually stopping us from doing something like that.
And you could have the appointments would work like way better too, because you could say like every single president then gets 2 Supreme Court justice picks.
Exactly.
And then you can rotate them out. They don't necessarily have to be lifetime appointments.
Who would choose who gets on like
which rotation? You wouldn't even need a rotation. You would just say you would only get I mean, like I agree with you on the rotation, but this makes it where it's like, no, you don't even need to rotate them. It's just however many there are, that's how many there are. If they all die in a fire and there's only 3 left, we've got 3. If they all live to be 500, well, we've got 1,000 of them. So what? You only ever get 3 judges on a panel, and then all the judges have to decide whether or not they're going to do en banc or not.
Sure.
How do you choose who gets to be like the 3 judges on like
you just
which
do it randomly.
case?
That's how we do
just
it.
random.
Yeah,
Okay.
right now we do. You just any judge appointment is random. You can't choose your appointments. Yeah.
Sometimes you get a bad judge.
Yeah, like Eileen Cannon, what I would call a bad judge. So yeah, this is a great ruling from the Fifth Circuit. It's going to be really. I don't know if I mentioned this. It's going to be really funny if it gets overturned by the Supreme Court.
Wait, you keep saying from the Fifth Circuit, but this was just a district court, so this has to go up to the Fifth Circuit now, right? The appeals court.
It's in the Fifth Circuit. You're right. I'm sorry. When I'm saying the Fifth Circuit, it implies the appeal court. It is not. It is in the Fifth Circuit. This is a federal district court within the Fifth Circuit, right?
I only say that because my understanding is the Fifth Circuit is generally seen as being a bit more conservative, right? So there might be like a decent chance that this gets overturned on the Fifth Circuit, and then it gets appealed to the Supreme Court, right?
Yeah.
But now the old district maps are back, correct?
As of right now, they should be, yes.
Got it. So then how long do we guesstimate, or we have just no idea, until like the Fifth Circuit picks it up and like does the whole fucking case?
It will be fast.
Or are we going to get
it will be fast.
It will be fast. Okay.
It'll be fast, and it's also at that court's discretion.
It'll be before like the next election that it'll matter.
Oh,
absolutely, yes.
Yeah, without a doubt. I mean, this case by itself was already pretty fast tracked. I believe it was filed. Yeah. So this was filed the change happened in October, and then they did a very fast oral arguments within it was filed in October. They did oral arguments in October for the preliminary injunction, and then this came out now.
Oh, damn, that's quick.
Later. Yeah. In some cases, it takes a really long time to get orders on preliminary injunctions.
Can the Fifth Circuit just say, fuck it, we're not taking it? Like, we don't think there's grounds? Okay, yeah.
Sure.
And if they
people
say
like
no,
have
then they'll
discretion.
be like, Supreme Court,
I don't know if they
help us?
I don't know if for this type of decision, I don't think they would ever not take it. They would just either affirm or overturn the lower decision, yeah.
Yeah, but it's just like mechanically they have discretion to choose which ones to take and which ones not to.
Got it.
But yeah, so it's interesting to see this come out of this court and have it go this way. You're right that it could go up to the Fifth Circuit and get overturned there and then go on to the Supreme Court. The issue is that this is so like dismally against the Voting Rights Act that they would have to basically just get rid of the Voting Rights Act to make it okay, like the Supreme Court would. And if they do that, then it means that currently the challenges against California and Prop 50 are all based off of racial gerrymandering under the Voting Rights Act as well. So if they just if they have to get rid of the Voting Rights Act to make the Texas gerrymandering survive, it will ensure that for now, at least the Californian gerrymandering will survive based on the challenges that are against it, which is
it's like a burn it all down solution.
Well, yeah, it's a burn it all down, but it's like they're damned if they do, damned if they don't, right? Because California, like I think that they didn't do racial gerrymandering, but they can't get rid of California's gerrymandering without the Voting Rights Act. There's nothing else that would really help them do that right now. And so because the funny part is that like California, as Dustin explained earlier, can just come in and say, no, we did this because we wanted to help the Democrats, which then makes it where the federal courts have to go, oh, we can't actually decide this.
Because everything's just
more
based
particularly,
on race.
they couldn't say that. Oh fuck, what's the legal term that they used? What is it? Yeah, they couldn't retroactively do that. They would look at the record at the time. So like if California right now was saying like, oh, let's racially, demographically change these things, and then the Supreme Court looked at it and like, hey, you can't do that. And they're like, no, we didn't do it on race. We did it on something else. Then they'd be fucked. But I assume they haven't had that conversation, not doing that. And that's the issue that Texas is running into here, where they're like, you're trying to say that this new Supreme Court decision on redistricting makes it so the 2021 districts were drawn improperly because they were racially motivated. But there's no evidence in the record that they were racially motivated. And the district court here says that Ken Paxton didn't submit any evidence that it was racially motivated, and it needs to be to use the recent circuit decision to say that they were done, illegally. Yeah.
So then the other aspect of like this, the other reason why this case I think is important too is because they didn't just do those 4 districts, they did like 9 districts all under this same thing. And then every single one, it's very clearly based off of race. So like the feds asked for 4, Texas did 9. And so like, it actually is like a really, it's much larger than what it initially seems like. And so like, it's really nice.
And this would give them more House seats?
Yes.
This would
for the U.S. House of Representatives.
Yeah, this would theoretically give Texas more House seats, or give the Republicans more House seats. Though there's been, I don't know if it's cope or if there's any actual like merit to it, but like the problem is that to make these new districts like this, they have to take strong red districts and make it where, like, let's say it's a plus 12 district. Well, they're going to put it down to a plus 7 district so they can take that 5 and put it in a district to make that district go from a plus 3 blue district to a plus 2 red district. Well, now you've got 2 districts that are actually a lot closer to being purple than they were whenever they were clearly red and blue. And so like what you're doing is you're saying like, okay, before we had there's like a 85% chance that Texas is going to go red in the election. By gerrymandering it, we get more House seats, but there's like a 65% chance that Texas is going to go red now. And depending on how, the political winds blow, and whether Democrats get more morale to go vote and Republicans get demoralized to vote, that 65 could get closer to 50, then get closer to like the Dems actually having chances of winning. And so that's a lot of reading the bones, and I'm sure a healthy amount of cope. But it is a real consideration that like just because you're redistricting like this does not mean it's a guarantee that you're going to pick up those seats, and it's certainly not a guarantee that you're going to pick up those seats in the long run, right? These kind of gerrymandering moves, when you look at them over like decades, often you'll see the things shift, and the gigantic majorities that you get out of it start to kind of even out and level out in different ways. There's how effective it's going to be if they get it is questionable, but likely it would help them out. Though California's move, Utah, and I believe Indiana is working on it, all are doing good work to counteract it. Utah recently went from a 4-1 Republican favor to 3-2 Republican favor for their House seats, and that was upheld by their Supreme Court.
Did you guys see the new Latino? I'm trying to find it right now.
That like
the Latinos
supposedly it's like minus 36 approval for Trump or whatever. Oh man, dude, I'm feeling my inner minority racism coming out from the. Remember the Bernie Bros in 2016, where all the white kids were like, "These fucking blacks turning against Bernie Sanders? Are you?" Oh man, for like 2 seconds.
What are you voting for?
They went deeper into the closet looking for those uniforms. They're like, "These guys don't know what's good for." Yeah, seeing all these fucking Hispanics, like, I actually don't like Trump now. I was like, wow, really, dipshit? You just figured that out? Good one,
Mr. Mooten. I think the issue is you're looking at a poll that isn't weighted to take out all the 30 million legal votes.
True.
Who got fucking kicked out? Yeah.
Because if you get rid of those, the Latinos still love Trump. So
they love him, dude.
Yeah. They weren't going to deport my type of Latino. So I don't know enough about the Latino community, but I did hear some people saying like, oh no, like some like ethnic groups, like, or people from like the Dominican Republic or something were like, no, I don't like any other type of Hispanic. As long as the Dominicans get to stay, get rid of all the rest of them. I don't know how true that was, but I thought that was
well, I can speak as a Cuban. That is, all Cubans think that. So 104 pages. Oh my God. In my 37 years on the federal bench, this is the most outrageous conduct by a judge that I have ever encountered in a case in which I have been involved. In summary, Judge Brown has issued a 160-page opinion without giving me any reasonable opportunity to respond. I will set forth the details. The readers can judge for themselves. Bam, he's mad he didn't get to write. What's the standard practice if they do these? Are they supposed to confer with each other? Do the judges have to? Or we will endeavor to get you a draft before we issue our injunction. Sadly, we do not believe we can wait for a dissenting opinion before we rule. The fuse is simply too short in light of Purcell. We will, however, note on the opinion that you are dissenting. We are not trying to cut you out. We just don't have time. Ideally, of course, we'd like to have you seen. Okay. Yes, you heard it right. To summarize, in case the reader doesn't get the point. Why? I feel like even when I was reading the majority opinion on this, are district courts just like less professional or something? Or maybe is it just Texas? I feel like the writing that I read, even on the majority opinion that was authored, it felt a little bit kind of memey. Yes, you heard it right. I feel like I'm reading a Substack. Judge Brown was announcing that he would issue an opinion 3 days later, an opinion that I hadn't even seen and might not be furnished before its issuance. That is unthinkable, but it occurred, and not accidentally. The outrage speaks for itself. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. What the fuck? Judge Brown could have saved himself and the readers a lot of time and effort by merely stating the following. I just don't like what the legislature did here. It was unnecessary, and it seems unfair to disadvantaged voters. I need to step in and make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous lawmakers. Just as I did to the lawmakers in Galveston County in Pedway, I'm using my considerable clout as a federal district judge to put a stop to bad policy judgments. After all, I get paid to do what I think is right. Jesus. This doesn't have any legal power, right? No, it's just a dissent. But there's the old joke. What's the difference between God and a federal district judge? Answer, God doesn't think he's a federal judge. Good one. Or a different version of that joke. An angel rushes to the head of the heavenly host and says, we have a problem. God has delusions of grandeur. The head angel calmly replies, what makes you say that? The first angel whispers, he's wearing his robe and keeps imagining he's a federal judge. Only this time, it isn't funny. I dissent. Do the district judges normally go this hard at each other? So when somebody says, when they're saying like imagining himself to be a legislator, when they're talking about disagreeing with the legislature, this is a dig at, just make sure that this is a dig at like what you are as a judge. A judge isn't here to decide legislation or what should or shouldn't be legislation. The judges are just here to rule on matters of law. Is the legislation that you passed, does it comport with your own laws or with the state constitutions or whatever? Not the state constitution, the federal constitution or federal laws, because this is a federal district court. Judge Brown is no stranger to a spirited attack on a legislative body's exercise of its duly elected power to redistrict. Before being roundly reversed by the Fifth Circuit, sitting en banc, Judge Brown, imagining himself to be a legislator, wrote the following. The ultimate question is whether unrestrained ideological judicial zeal should prevail over legislative choice. This isn't my first rodeo. 14 years ago, dissenting from a flawed 3-judge redistricting order in this very court, I wrote the following. So in my understanding, the biggest issue is that the government seemed, if I'm to assume that the judge that wrote the majority opinion is correct, the government just didn't provide any evidence for why they were suggesting new maps. They claimed, apparently, that they were doing that because the 2021 maps were racially motivated, but they didn't submit any evidence for that, in which case, then it seems like you're likely to lose your case. So does he speak of any evidence that they put in? Is he going to give that evidence in his dissent? Or speaking of fortune, just a few weeks ago, the Fifth Circuit answered the main question at hand, holding that the most obvious reason for a mid-cycle redistricting, of course, is partisan gain. The question for this 3-judge district panel is whether the Texas legislature did its mid-decade congressional redistricting to gain political advantage or, instead, because the main goal of Texas proposing a legislature is to slash the voting rights of persons of color. Once again, here we go again, criticism of the behavior of DOJ lawyers in last decade's redistricting battle. I noted the following. The U.S. is no longer participating in this instant case. The same attitudes about Texas proposing a legislature. It's all politics on both sides of the partisan aisle. George and Alex Soros have their hands all over this. This guy needs to go, bro. Is this guy schizophrenic? One of the plaintiff's top experts is Matt Barreto. He is a paid Soros operative and does not attempt to hide it. His CV confirms it. He expects to receive $2.5 million from George and Alexander Soros. Matt Barreto is a professor of political science and Chicano and Central American Studies. Okay, and he's co-founder of the research and polling firm BSP Research. Is there a way to see these exhibits? 269. Okay, so it sounds like he got a grant from the Open Society Foundation, which, I'm guessing this is like founded by George Soros. Does he run the whole thing, or is this just like a giant? Their revenue is $436 million. They have a $5.3 billion endowment. So every single society or organization that takes money from this, you say is funded by Soros, I guess? Okay, based. Nice, okay. Nor is this something new. Soros has been pumping money into Barretto's UCLA voting rights project for years, and this steady supply of money won't stop until 2026 at the earliest. Unsurprisingly, Barretto has been on quite a roadshow for years, parading across the country opposing Republican redistricting. This is the tip of the iceberg. The lawyers are involved as well. Excuse me, sir. Are you a journalist or a lawyer? Where are the legal arguments? Hello? What am I reading?
He's a judge.
Or a judge, yeah. To his credit, the lead counsel for plaintiffs does not try to hide it either. On a silver platter, Judge Brown hands Soros a victory at the expense of the people of Texas and the rule of law. Judge Brown won't tell you that. I just did. Relatedly, Gavin Newsom took a victory lap in Houston to celebrate the Democrat redistricting win with Proposition 50. Indeed, he did so on rival Governor Greg Abbott's home turf Saturday and called on other blue states to push back on a GOP effort to retain control of the U.S. House. And after the improperly premature issuance of Judge Brown's opinion, the Houston Chronicle pointed out that Governor Newsom quickly tweeted, "Donald Trump and Greg Abbott played with fire, got burned, and democracy won. This ruling is a win for Texas and for every American who fights for free and fair elections." That tells you all you need to know. This is about partisan politics, plain and simple. I dissent. I suppose someone will say that in making these comments about the Soros connections, I'm expressing a political view, not the proper role of a federal judge. Oh, he's talking to me. To the contrary, as I say above, the political branches engage in policy and politics. It's our job as judges to let that happen, but it's also our duty to recognize the societal and political effects of what we do, regardless of whether we approve of those downstream results. Today's ruling has dramatic political consequences by meddling in the orderly process of a duly elected state government. It's not political for me to point out that by describing the political dynamics are inherent in the litigation of redistricting cases. Jesus Christ. Judge Brown has a lingering habit. He correctly recites part of a legal principle, then veers off track along a spectrum, intentionally misleading at best to false at worst. The opinion is replete with selectively copying and pasting parts of legal rules or standards. Beyond that, things get dicey. This holds especially for Judge Brown's discussion of the standard for a preliminary injunction. Okay, it's 4 parts, right? It's you have to show likelihood of success on the merits. The party moving for a preliminary injunction needs to show irreparable harm if it's not granted. I think you have to show it's not unduly burdensome for the defendant. And then I think it has to be in the public interest. Judge Brown admits that the first factor, likelihood of success on the merits, is the most important, and that granting a preliminary injunction is an extraordinary and drastic remedy, which should not be granted unless the movement clearly carries the burden of persuasion. Is there a most important factor? I mean, I guess, but all 4 of them I believe are considered elements. All of them are necessary. Not a single one is sufficient. So if you can show 3 or 4, you still fail on the preliminary injunction. But this is a nitpick, I guess. That granting a preliminary injunction is an extraordinary drastic remedy, which should not be granted unless the movement clearly carries the burden of persuasion. Then the opinion entirely goes off the rails. Judge Brown quibbles with the omission of the word substantial next to the phrase likelihood of success in the merits in the Fifth Circuit mid-decade redistricting opinion from just a few weeks ago, claiming that the omission suggests that the plaintiff need only show a likelihood of success on the merits. This is intentionally misleading at best and disingenuously false at worst. How does he get there? Judge Brown justifies his wish list formulation of the first factor by noting the factual similarities between Jackson and the instant case. Both involve Texas mid-decade redistricting. Surely he knows that the phrase extraordinary and drastic remedy never appears in Jackson. Judge Brown, relying on the factual and procedural analogies between the 2 cases, would lead the leader to think that gives him carte blanche authority to exercise the extraordinary and drastic remedy from his opinion as well. Nevertheless, he keeps the phrase extraordinary and drastic remedy in the standard because he knows he cannot remove the phrase at will. Judge Brown, no stranger to inconsistency, is wrong. He should give less consideration to the omission and more consideration to the actual words on the page. Judge Brown accurately cuts and pastes the following. A preliminary injunction is an extraordinary and drastic remedy which should not be granted unless the movement clearly carries the burden of persuasion, and the likelihood of success on the merits is the most important factor of the framework. But the cut and paste job is selective. Judge Brown left out the fact that giving attention to the relevant cases cited in Jackson, the most important factor language in Jackson is a direct quote from Mock v. Garland, and any cursory reading of Mock, easily reveals that the word substantial, the word Judge Brown tries to avoid, is part of the first factor in no uncertain terms, a substantial likelihood of success on the merits. Judge Brown doesn't tell you that. I just did. Wait, what? I'm sorry, hold on. What was the, does anybody have the ruling? From yesterday. Oh, here they are, the 4 factors. Besides showing that they're likely to succeed on the merits, plenty of reasons establish they are likely to suffer irreparable harm. So this is the irreparable harm element. Balance of equities and public interest. Is that... I'm just curious where he goes over the... Usually it'll be near the end of these rulings is they'll go over the 4 factors of the preliminary injunction. And I see them going over the last 2. So I'm curious where they go over the likelihood on the success of the merits. Some Fifth Circuit opinions state that a plaintiff seeking a preliminary injunction must show a substantial likelihood that he will prevail on the merits, whereas others state that the plaintiff need only show a likelihood of success on the merits. See Jackson. Oh, okay. So this is where he... We will go with the language of the Fifth Circuit's most recent redistricting opinion, since it's the preliminary injunction opinion that's most factually and procedurally analogous to the instant case. Either way, given the Fifth Circuit's sliding scale approach to the likelihood of success inquiry, see this, and accompanying text, we perceive no substantive difference between the 2 formulations of the standard. Okay. So the judge is arguing that whether it says a substantial likelihood of success or a likelihood of success, he's saying it wouldn't really make much of a difference anyway, I guess. Okay. And how they weigh it. I don't know if that's like a substantial likelihood versus like, I don't know if this is like, I don't think these are legal words or anything either, but he's real mad about the omitting of that word. Claiming omissions, here's the plaintiff need only show a likelihood of success on the merits. This is intentionally misleading at bad. How does he get that? Okay, this is cringe. The opinion is caught in an illogical straitjacket from which it cannot escape. Knowing that his argument is weak, Judge Brown declares that the omission of the word substantial does not matter anyway. Oh, he deals with it because the Fifth Circuit sliding scale approach to the first factor, which is likelihood of success, with a magic wand, the quibble of the word with the omission of substantial is no longer consequential and vanishes into the ether. This is part of the activist, result-oriented bag of tricks that tinkers with the allegedly most important first factor, such that the quibbles that he proclaimed matter no longer do. Judge Brown says, where the other factors are strong, the movement need only show some likelihood of success on the merits to obtain a preliminary injunction. This is intentionally misleading at best, disingenuously false at worst. I feel like he's done this thing like 3 times. Is this AI writing? I feel like he's done this thing. This is blank at best, and this is
Put him into an AI checker.
True, check it. There he goes again. Judge Brown overlooks what immediately follows the passage on which he relies. Where other factors are strong, a showing of some likelihood of success on the merits will justify temporary injunctive relief, but when a plaintiff applies for a mandatory preliminary injunction, such reliefs should not be granted except in rare instances in which the facts and law are clearly in favor of the moving party. What's the difference between temporary injunctive relief and mandatory preliminary injunction? Aren't preliminary injunctions definitionally temporary? Judge Brown is wrong on multiple levels. First, he claimed that the first factor alone suffices, indicating that the other factors do not matter. Did he? Second, the other factors discussed below are extraordinarily weak in this case. Third, Title Max differentiates between temporary injunctive relief and the narrower category of a mandatory preliminary injunction. What's a mandatory injunction? Aren't all injunctions mandatory? Are there such things as an optional injunction? What does that mean? He might be referring to the difference between a TRO and a PI. TROs are usually limited temporarily, while a PI can be for the length of a trial. So this might just be a TRO. This might be for a preliminary injunction? Maybe. I would have to read this underlying case. I don't care that much. A mandatory injunction is issued when a court directs a person to perform certain acts, as opposed to a prohibitory injunction, which seeks to preserve the status quo. Oh, okay. So a mandatory injunction is actually forcing you to do a thing, and a prohibitory injunction is just enjoinment to preserve the status quo, I think. But this would be a preserving the status quo type of injunction, no? They want to preserve the 2021 maps? Or would it be considered a mandatory injunction because they want them to roll back their 2025 ruling? I'm not sure if this would be considered a prohibitory or mandatory injunction. I don't know. Third, temporary injunction, narrow category, mandatory preliminary injunction. Judge Brown must surely know that, which is likely why he cherry-picked the language he liked, omitted the language he didn't, and inserted what he wanted, a preliminary injunction.
Did he write that? Oh, he did. What the fuck?
If this is not judicial activism, I'm not sure what would be. Fourth, Judge Brown is issuing a mandatory preliminary injunction because he's enjoining, I wonder what the argument is. So he's enjoining the implementation of the 2025 Texas congressional map and requiring Texas to use the 2021 map. Enjoining sounds definitionally like the prohibitory. Is there like a legal way I can look this up? An enjoinment to me, enjoining somebody from a behavior sounds prohibitory as opposed to forcing them to do something different. This is a preservation of the status quo. That's what it sounds like to me. If this were a law school exam, the opinion would deserve an F. Remember that recent Fifth Circuit redistricting case, the one that Judge Brown said was procedurally and factually analogous to the instant one? No question mark. Argument defeated. Can't an injunction be both mandatory and prohibitory? I don't know, maybe? Like if I'm paying somebody and I get sued or something and they get an injunction and I have to keep paying them, would that be considered mandatory or prohibitory. It could be mandatory because you're telling me I have to do an action by paying them continually, but it could be prohibitory because you're trying to preserve the status quo and you're preventing the implementation of a change in pay schedule. I'm not sure. I don't know if there's like a strict delineation between these things legally as well. I don't know. I just don't know. Judge Brown is an unskilled magician. The audience knows what is coming next. What? The last time I checked, a preliminary injunction is an extraordinary and drastic remedy. This is serious business that we are about. Jesus. Judge Brown boasts that plaintiff groups have successfully shown a likelihood of success on their racial gerrymandering challenges, and that alone suffices to preliminarily enjoin 2025 map. But it wouldn't, right? This would be incorrect if he says this. At page 54. The legal standard for obtaining a preliminary injunction. To obtain a preliminary injunction, the plaintiff group must show, so he has, these are the 4 elements. The plaintiff groups have demonstrated a likelihood of success on the merits of most of their racial gerrymandering claims. For the reasons explained below, the plaintiff groups have successfully shown a likelihood of success on their racial gerrymandering challenges to CDs 9, 18, 27, 30, 32, and 35, because that alone suffices to preliminarily enjoin the 2025 map. And given the short time frame the court had to write this complex and record-intensive opinion, the court will not address the plaintiff group's intentional vote dilution claims at this time. Kafka, wait, do you understand what he just said here? I don't like reading this stuff. I'm done. I want to play video games. Wait, do you understand what happened here?
Didn't he just say, like, well, the court doesn't have time to go through it, so they don't even have to do it? Or something like that?
Kind of, no. Judge Brown here is being misquoted by this guy, the Jerry dude. Okay, you and me want to go out to eat. Let's say that there are 2 different things that I have to show for us to go out to eat, okay? The first thing is I have to show that you and I are hungry. And then the second thing is that I have to show that we have enough money to go. Okay, those are the 2 things that I'm required to show. All right. Let's say that for the first element, okay, so I'm going to prove that we're hungry, and I'm going to do this in 2 ways. I'm going to do the first showing is I'm going to say we both said that we're hungry, and then in the second showing, I'm going to demonstrate that it's been 16 hours since our last meal. Okay, and then for the second thing, I'm going to show the money in our bank accounts. Right? You following me so far?
Oh yeah.
Okay. So let's say that I go to make the argument and I say, and now a judge is reviewing our decision to go out to eat. And the judge says, okay, so we're looking at the first element that needs to be met is you have to be able to say that you guys are hungry. So we looked at this, and on the subsection for the first element, you've said that both of you have stated that you're hungry. Because you've stated that, we don't have to go into the second part. We don't need to make that decision at this time. We're going to move now to the second element. He's pretending that by making that statement, that Judge Brown is dismissing the other 3 elements of seeking the preliminary injunction just because this guy said we have enough to satisfy the first element, and so the court will not address the rest. So he's just, unless this guy goes on to say, that's how I read this. Do you understand what I'm saying, Kafka?
Yeah, he's, for some reason, you're correct that he's misquoting him, though he's also kind of overstating his argument where, like, those 4 different factors, any one of those 4 factors could overpower the other 3 and make it where a preliminary injunction is okay. It's possible that the other 3 factors against giving a preliminary injunction, but this factor is so strong that they still should grant it.
When you say against, a good way to wait, they have to be in favor though, no? Like all 4 factors need to be met.
No. They need to be like, you can say like this is something that is slightly against public opinion, or like an example to be given is like because like cutting against, I guess, that might be too strong, but in the sense of like it wouldn't reach the burden on its own is a way to say it, right? Like,
sure.
And if this one factor wasn't so strong, these other 3 would not carry it. So like the classic example is like, you've got a woman who shows up and she's like, I'm a victim of domestic violence. If I go home, I'm going to be killed. I need a protective order to keep my husband away from me, right? It's like, okay, well, the potential harm, irreparable harm here is so high, even if maybe she can't win this case, like I'm looking at it right now, it does not look like, I can't make a determination that she would be successful in the merits, right? The likelihood of success like here is not high. However, I believe in this moment that if she goes home, she will die. So yeah, we should file this to get this protective order put into place.
Well, I feel like when you're doing that, when you're weighing that evidence in the beginning, so if we're talking about a TRO, this is ex parte or whatever, right? You're just assuming that everything they give is true. So then you can say, I think you still make that determination. So like, let's say a woman comes in and she says, I need a protective order. My husband is going to kill me. And it's like, okay, well, why do you think this? And she's like, I deleted his save file for Final Fantasy Tactics. Like, has he ever hurt you before? It's like, no, but I think he's going to be really mad at this. Well, in that case, it doesn't seem you have a likelihood of success on the merits. It seems like you're being retarded. But if she comes in and she's like, my husband is like threatened to kill me and he's beat me before, like, please, give me this, whether or not she's being honest or not, if he's just reading the facts as given, then you'd say, okay, well, your likelihood, assuming these are true, these allegations are true, at the very least, I can issue a TRO. Like, I think they're still succeeding on all 4 merits, right? It's not overly burdensome on the husband for a protective order to be issued. It's obviously in the balance of public interest. Whatever the second factor is, I'm sure that's met as well.
You don't need to hear the husband's side at all before you
give it. Well, first, we can make it a PI and discuss it in that,
sure.
Because it's a little more analogous. But like real quick though, like let's say it is a PI even of that, where like, Your Honor, if we need to have a PI hearing because if I go home, I'm going to get killed, right? And she shows up and she goes, yeah, he's going to kill me because I deleted his save file. And that's why, and I'm basing all of my domestic violence stuff based off of pure hearsay. There's no concrete evidence. I can't actually bring anything into trial. But here right now are text messages from him showing that he say he's going to kill me. Here's evidence of him buying a gun that he's never had before after that. Right. And this, it's like, okay, well, even there you're like, okay, I could see this as being like a credible threat, but not succeeding on the domestic violence thing. I'm just saying, like, the likelihood of success there is so low that it can't carry it. There's not even really like a lot of weight there to give to the PI. But the threat is so great that you would say, yeah, maybe there's not a high likelihood of success, but the threat is so great that I'm still going to grant it. And in here,
I guess the confusing part for me,
could be a similar thing.
I guess the confusing part for me actually, because I guess now that I'm considering this, is the likelihood of success. Is it to win on a criminal conviction, or is it to win? Because for civil stuff, it's for the civil stuff. So I guess I don't know how that would work, I guess.
Wait, no, just the likelihood of, like there's a likelihood of success of whatever claim is being brought, right? And a criminal, actually, there might be a little bit different in how they're doing it, because I did use protective order. It's just like, that's kind of the classic to show like the balance differences, right?
Sure.
But for here, we can go back to here where it's like, okay, their likelihood of success here is super high. Right, and let's say the potential damage is irreparable, but the amount of damage there is not like severe, right? You might say, well, it is irreparable, and they're really likely to win. So yeah, let's just go ahead and put this in place. And so,
so wait, just real quick on what you're about to go into, like that. Sure, I can agree with that or whatever. That something is so high, but my big issue here is that what Judge Brown is saying in his ruling is when he says, because that alone suffices to preliminarily enjoin the 2025 map, he's saying that plaintiff groups have successfully shown a likelihood of success on their racial gerrymandering challenges, and because of that, that's enough to preliminarily enjoin the 2025 map. And given the short time frame, he says that that's enough. The court will not address the plaintiff group's intentional vote dilution claims at this time. What he's saying is that they've shown enough to satisfy the first element. And then he's going to move to the next 3 elements for analysis, I think. But the Jerry here is trying to say that when he says that, he's actually saying the next 3 elements don't even matter, which I think is not what is being said.
Yeah, you're right about that. And there's another layer too, where the judge is saying it is sufficient for the claim that there is an intent to racially gerrymander, right? Sure. This section right here is specific, that you've got highlighted, is specifically about, hey, there are 3 claims. One is about intent to racially gerrymander the state, and there's these 2 other ones that have to do with vote dilution, and one of them doesn't require intent. And the judge here is saying, I've got enough in that first one to start looking at preliminary injunctions, so I don't need to even address these other 2 claims that they brought.
Because when lawyers are submitting things, you're going to make like multiple arguments to satisfy your thing, right?
Exactly.
Well, even if this fails, then we should look at this. And if you're limited on time, then if the judge has enough to satisfy, then they won't go through the rest, right? Yeah.
Right, and the judge is saying here, like, it also makes sense too, because vote dilution generally is an effect-based claim, and so you look more to the effects when you're doing vote dilution, I believe, and so like, since this is before there's any votes even happening, it would then be harder to show the effect. Though I believe they actually provided enough evidence for all this stuff. I'm just saying, like, if you can show intent, it's the easiest, most direct way to do it. That's why you would focus on it primarily the way the judge did.
Yeah, it just seems like he's misquoting him here, or he's misunderstanding.
Yeah, no.
If we were to take him at his word that the first factor is dispositive, it is not, to grant a preliminary injunction, it's not apparent why Judge Brown feels the need to discuss the other factors. Is this guy retarded?
Yeah, he's saying on the one hand, like, oh, he only cares about the first factor, that's why he doesn't talk about the other 3, and then he goes, well, he still does, which I don't understand why he does.
Yeah, but it's...
Right, and then he goes, wait a minute, but he does talk about it. I don't know why he does, because I just said that he didn't, but it's not my fault. It's the other judge being ridiculous. And it's like, or you're being bad faith. Yeah.
Dude, are district judges normally so crazy? Is it just circuit court and Supreme Court that write better, or is this like pretty standard for?
You get some pretty wild stuff in the depending on who you're in front of. If you're at the district court, that's the lower stuff. So like you can see some crazy stuff there. This is particularly unhinged, especially like this much. I'll say this: I've rarely seen judges in the federal courts be this like nakedly partisan and willing to attack fellow judges.
Attacking fellow judges like really, crazy is yeah.
It's really weird that he's attacking the fellow judges. It's like I would, in a normal scenario, if we were not in this current reality, a judge doing this would almost certainly face some kind of censure.
Can you put in like a bar complaint for this or no?
The judge.
You would go through the judge. Yeah. You would go through the judges, like the Fifth Circuit itself would issue a censure.
Whether Judge Brown likes it, gravity exists. Second, Judge Brown's late-breaking 11th hour injunction is precisely the kind of judicial tinkering and judicial altering that the court has repeatedly warned us about. I guess Judge Brown needs another reminder.
It is kind of weird considering, isn't Judge Brown the Trump appointee who wrote the opinion, and then this guy is the Reagan appointee? So it's like
supposedly, yeah,
extra strange. Yeah. Okay. You didn't read through the full other opinion, did you?
No, not all of it. I skimmed a little. Why? What about it?
The section on the expert witnesses is actually really interesting. If you want to have like a pretty in-depth discussion ever about gerrymandering in a debate or something with somebody, if you read through that stuff, it does a really good job of showing like the actual data and like how the guy that made it, even though he's claiming all these reasons why it was not racially determined, it shows why that is not credible. And then they go into the plaintiff's expert witness, and they have some really awesome data or whatever the tech word is for their charts to show how it is very obviously racially gerrymandered. So
just curious,
it would be a really, really good thing to know.
Could the Texas state legislature have redrawn these districts using the same process and procedure they did if they wouldn't have claimed the violation of the Voting Rights Act, or would they have had to have done some different process, some state?
What do you mean exactly here?
Because my understanding is that the reason why the district court is hearing this case is because this redistricting has been done in a way that it only could have been done because they're challenging the 2021 maps due to the fact that they were racially motivated. And apparently now they're saying that that's not okay because of what the DOJ said. But my question is if they were to have just like voted for new maps or whatever, they could have just done that, right? But is there a different process or procedure they'd have to do?
I believe you're correct that there is I'm not entirely sure of the Texas procedure for drawing new maps outside of a census, but I believe there is a procedure beyond just going in like they did, because they need to have a purpose in doing so, and I don't believe they can like initiate and draw new maps just because they want a partisan reason. They did need to have some kind of legal challenge that would allow them to do this. Texas, I know for a fact they could have done a referendum similar to California, almost certainly, because Texas, they do any kind of stuff like this. They would do a Texas constitutional amendment, and then that amendment would grant the legislature the ability to change the map.
So you're saying what I'm asking is what blocks them from just changing the legislature, just changing it now, assuming it wasn't done illegally before? Could they just change it, or is it like in their constitution that it's every 10 years?
I really, this is not an area of my expertise, but I thought there is some kind of provision, something that makes it where the Texas redistricting, there's a committee that allows them to do it, and then I believe there's some other rules that are in place, because otherwise they would have just done it. I'm not sure why.
Section 28, Article 3 of the Texas Constitution requires the legislature to redistrict state house districts during the first regular session following publication of the decennial census. Okay, so this is why they have to. Somebody asked in chat, wait, so the redistricting was never voted on like it was in California? They're just trying to do it based on some claim of racial shit? Correct. They didn't do a vote on this at all. It was just the state legislature doing it at the behest of Abbott.
Yeah.
Texas courts have allowed a House plan to violate the county line. Okay, never mind. Sorry, go ahead.
So but then at the time I was watching the Texas committee on the redistricting stuff, and I believe that there were some pretty good speeches from the Democrat side on how this actually is still violating it in any ways. Like there's a lot of like signaling ahead of time that they should not be doing this at all. Even Ken Paxton came out and said that they shouldn't do it, I believe, or something to that effect, where Ken Paxton was like, this is bullshit, but I guess we're doing it. And so this is well outside a lot of their normal procedures, and it was very obvious. So it's weird to see this level of dissent on something that's so plainly illegal. Yeah, I think that people saying that this guy is trying out for Supreme Court are correct. This guy's just trying to curry favor with Trump.
Did you read through the witness and everything? So when they did the maps in 2021, do you feel pretty confident saying it definitely wasn't based on race? Like if you had to venture like a guess percentage that like, oh no, this was not racially motivated or whatever.
Oh no, I would like 90% surety that there was no racial motivation to it. I mean, like I would put it at 99.
So like 6, maybe 7% that there was racial motivation.
Like I could see there potentially being some, though I don't think that there's any. I'll say this: I'm 99% sure there's no evidence of it, either the intent or any effect that would implicate like these laws. But like the question and their theory that they brought up about the racial drawing of the maps, like the theory that they have, is like 99% sure that didn't happen. That was not a like violation of the voters' voting rights.
And it
Act.
sounds like they didn't submit any evidence of this. We'll see if Jerry fucking gets to any once he's done ranting about Soros. But okay, gotcha. I see. Okay.
Because they would have. So like if their legal theory worked, they're basically saying like, oh, like we wouldn't need to submit evidence because it's obvious that it is a violation because these districts were formed with that. I believe I mentioned last time the coalition districts. The idea that you could have these like racially diverse districts that don't have a majority. And there was a court that came out and said like, oh, the Fifth Circuit said, oh, those don't actually function the way that we said before, which has to do with other type of gerrymandering issue. But the court did not say, because it doesn't work in the way that we said previously, that makes them unconstitutional. That never happened. But the government right now is assuming that these coalition districts have become unconstitutional by merit of that Fifth Circuit decision. And now the Fifth Circuit is saying, we never said that. There's no evidence that we said that or even intended that to be what the decision is about. And so that's why they felt like they didn't need to submit evidence. You have anything else? I was going to hop off.
No, it's kind of ironic that technically the process by which the state legislature is doing here is actually circumventing the will of the Texas voters, right? I don't know if they have a procedure to do a proposition to redistrict, but they're just what they're really doing is they're saying that they were racial in 2021. They're relying on some bullshit argument from the DOJ to say that that's now not okay because of some Fifth Circuit decision. And so therefore those maps are invalidated. So now we're just going to suggest a new one like we have the right to do. But none of this was actually voted on by the people of Texas or anything else. They're just trying to invalidate the 2021 maps and suggest their own new maps is what's happening, right?
Right. And the procedure that they could do is and there was recently a special election in Texas in November. They could have put an amendment to the Texas Constitution in that election to allow the people of Texas
to do
to decide whether or not they wanted
redistricting. Yeah, but they didn't do that. Yeah, because they're pussies.
Right. So it's interesting. Yeah. So it's like, oh well, we know we can get away with it and not have to actually put this to a vote. But what's funny is like even if they did that, it's not clear how that would help them get around the issue they're seeing right now, right? Like even if it was 100% vote that the Texans people wanted to redistrict based on race, it still violates the Voter Rights Act, and they're not allowed to do that. So it's not like that wouldn't even save them. But it would at least like
the reason why they have to bring up the racial thing now is to discredit 2021. They don't have to say right now that they want to redistrict. They could just say we just got to redistrict, and then the people could vote on it, and they know that they're going to get a partisan redistrict, but that would be okay. They would comply with the law and everything. Right?
Sure. Yeah. Okay. Yeah. That you're right about that. Yeah. True. That makes sense. But I mean. I would be surprised if the Fifth Circuit appeals courts overturned this. I think that we would have to see the Supreme Court overturn this for this to actually overturn. Even as conservative as the Fifth Circuit is, I don't know. It would be surprising to me if they overturned this.
What is the basis by which? Why is this a federal court issue and not a state court issue?
The Voting Rights Act is a federal law, isn't it?
Yeah, but it would only impact Texas through incorporation, right? Like why? Like this feels like a state court issue where Texas is basically trying to say our 2021 maps are invalid, so now we're going to do new ones. And then why would the federal government have the jurisdiction to hear this challenge? This would be between voters. I imagine all the plaintiffs are based in Texas, right? So why would the voters have the right to choose a federal court? Why would a federal court have jurisdiction over these issues?
Because of the Voting Rights Act is a federal law, so they have federal question. You have federal question jurisdiction. So it's like, hey, they're violating a federal law, so we want to go to federal court.
But aren't they isn't the argument from the plaintiffs that the federal law is not involved here at all? That there was no racial gerrymandering in 2021, so it's not even involved.
Well, that's a determination for the federal court. The question of whether or not that federal law is important is a question for the federal court, right? Because there's no, as far as I understand, there aren't any state law claims here, right? There aren't any Texas state law claims saying, hey, you guys are violating a Texas.
Well, no, there was. This is a state law
statute.
claim, isn't it? You're saying that the state claim, I imagine, would be, hey, you guys are gerrymandering in the middle of the census time. You're not allowed to do that. So I'm suing you in the Texas court because you're not complying with the Texas laws. You're violating your own articles.
They're saying you guys are using a federal law to justify your actions.
Correct.
We don't think that federal law your use of that federal law is legitimate. So then a federal court needs to come in and say, is this federal law being enacted correctly? Is it being implemented? Are these people acting within the scope of a federal law? And if the answer is no, then whatever they're doing, like just by operation of law, does not take effect, right? Like it's not like, because their justification for their actions would, as you say, disappear as a function of the Texas Constitution. Now, if they continued with it and said, well, we're going to do it anyways, despite the federal courts doing that, I guess there's also a Texas constitutional claim that you could come in and say, well, this is like in violation of the Texas Constitution. You don't have the right to do this. Those maps haven't been made defunct or whatever the term might be, so that we need new ones. So yeah, I think I mean the federal question here is very relevant. Now, to be fair to you, I mean, like, they could have brought it to a state court. You can bring a lot of federal claims in state courts.
Sure, but I understand now, even if you did this as a state claim and it got all the way to the Texas Supreme Court, it is ultimately a federal question, right? Because then appeal if you appeal from a state Supreme Court, does it start then at a circuit or district court, or does it go right to the Supreme Court?
Okay. There are specific rules around this. So like, it can depend on the type of appeal you're doing. So if, like, for a lot of criminal cases, you might not go straight to the Supreme Court. You would go to, federal circuits because of the appeals process there, because you have a federal appeals process in that.
Sure.
For like civil stuff like this, like, Bush v. Gore, that went from the federal, or from the Florida Supreme Court straight to the federal Supreme Court.
Sure,
right?
gotcha.
Because federal Supreme Court has the ability to overturn that decision.
Sure. So in deciding whether or not the Article 2 or Section 2 or whatever, the Voting Rights Act applies to this claim, that is a federal question, not just a question of incorporation. It's a question of, like, how do we interpret this federal statute? So the jurisdiction would be appropriate for a federal court, I guess, right? So this makes sense, I guess.
Yeah, right. Also, like, there's just a lot of very good reasons to bring stuff like this in federal court. And you really wouldn't, if you think about it, you really wouldn't want a state court to decide, in my opinion, the rules around this kind of redistricting question. I think that whenever you look at something like this, where they're relying on a federal law to overturn previous maps, I think in my mind, I would prefer a federal court, because you. Well, wait,
hold on. This seems like. Hold on. Actually, wait, I'm going back and forth on this. This seems like it's not a question of law, though. This seems like it's just a question of fact. Okay. Am I wrong in that? Like, the question is if they did use racial determination to do districting in 2021, then it seems like that's just a fact-based question, and that's not okay, is what we're assuming right now. That's not okay. That would just mean that it would get struck down, right? But
technically, so it is, whether it's a question of law or a question of it could be both. It can be both a question of fact and a question of law. What's happening here is that the plaintiffs are saying this is not a question of fact. There is no question of fact about this, because if we assume everything they say is true, they still would not succeed, because the way they're interpreting the law is not correct. And under the correct interpretation of the law, they cannot be correct.
Wait, but aren't they saying, does the law allow you to do racial redistricting?
No, it does not.
Aren't they claiming they did racial redistricting?
They're claiming they did it because of but using an interpretation of a Fifth Circuit ruling. They're saying the fact question could only be actually, like, determined or answered as a fact question if their interpretation of that Fifth Circuit opinion was correct. So they're coming in because right now.
Oh, like it has to do with something of like an effect or whatever. They're saying they're not necessarily. They're saying that our factual findings don't have to be that you said we're going to racially make things up, but it could rely on the fact of like these coalition things or whatever. That could be factually sufficient. And they're saying, well, we don't disagree on the facts here. We disagree on the legal interpretation of whether these coalition styles of doing districts legally satisfies or not. That's what the legal question is, right?
Exactly.
Okay,
And so if that federal legal question then gets answered of the plaintiffs are correct, we never need to look at a factual question around whether or not they were racially gerrymandered or not.
Okay, interesting. Well, what is your expectation? Do you think do you think the Supreme Court hears this case and makes a ruling, or do you think that the circuit court just, stays the lower court's ruling and the Supreme Court just doesn't hear it, or?
I'm trying to be less jaded and
channel your inner IRI.
I'm willing to inhale some copium and say I think this goes to the Fifth Circuit appeals. They uphold this decision, and then the Supreme Court passes on actually hearing it, and the 2021 map stands. Mm-hmm. I think that's where we're going. I think that's what I'm going to say is my guess. I think my second guess would be upheld in the Fifth Circuit. Supreme Court shadow docket denies it. Or
shadow docket is crazy.
I think that's the like second most likely route for this. How about you? What do you think? What's your gut telling you?
I don't know enough about the underlying. I don't know enough about that Fifth Circuit decision to really say. I would have to understand way more of that.
Don't go read it. It's pretty boring. Okay. Yeah. I mean, well, no, but I mean, like, do you think we can ask a different question though? Like, do you think that the Supreme Court that we have is unhinged enough to come in and make racial gerrymandering legal again to protect Republican majorities?
I don't know enough about the underlying legal argument from the Fifth Circuit opinion. Maybe there's a way to do that and be narrow enough to protect what the Republicans want, but not broad enough to give Democrats what they want. Maybe, I don't know.
Okay. So you think they might come in and go, that underlying Fifth Circuit thing actually did make coalition districts unconstitutional, so it's okay that they're doing this. That way we get to preserve the Voting Rights Act and say racial gerrymandering is bad.
Yeah.
And then they can go, well, so since that one that means that all they were doing was breaking up the racial gerrymandering. That's the only question we're going to answer. We're going to push it back to the district court and say, okay, with that in mind, even if they are giving all these racial reasons to do it, would we still block them? But see, even in that case, even if we made the Fifth Circuit underlying case make the coalition districts unconstitutional, it doesn't change the fact that the current maps would be unconstitutional. They could get rid of the 2021 maps, but the current maps, 2025 maps, would still be unconstitutional if you make that underlying case.
Sure. Yeah. It's hard to know without, like, I know, like, for instance, when the government, when they did like the TikTok case in the Supreme Court, that was written literally as narrowly as possible. They might have literally even said this is probably only going to apply to the company of TikTok because they wrote it so narrowly. So, but I just don't have a good understanding of all the underlying legal arguments. I wouldn't be able to say. Who knows? Who knows? But damn, if it doesn't, if they get fucked on this, they fucked up pretty hard because Newsom got his maps for California. That'd be pretty crazy.
Yeah, that's kind of the dangerous part, though. I think that. Do you think that there's like enough wind is coming out of the sails of the conservatives, where like if like all the Epstein shit's going on, you see these like fracturing, and then let's say like Texas doesn't get the redistricting. Do you think that that's enough of like a morale hit to like actually put them on the back foot where they can be feasibly defeated, or do you think that like
I think they're on a big back foot right now? No, I think that
that's what I mean though. It's like this would be like a 1-2 punch. Like, hey, look, like you're losing the fucking media fight. Also, get fucked politically. You're not actually going to get to steal the Congress for the next however many years, right? Mm-hmm. Like, does this feel like a nail in the coffin to you, or?
I mean, it'd be bad, yeah, for sure. But I think weren't they already slated to do poorly in the House, even with all these memeries?
Yeah, I was seeing like, it's hard to know if it's cope or not, but I was seeing some stuff where it was like, yeah, like this will make it where they're like stronger than they should be, but like this isn't going to save them.